Order. Can I remind honourable members that there have been some changes to the normal practice in order to support the new call list system and ensure that social distancing can be respected? Members should sanitise their microphones using the cleaning materials provided before they use them and respect the one-way system around the room, which is that way. Members can only speak if they're on the call list. This applies even if debates are undersubscribed. Members cannot join the debate if they're not on the call list. Members are not expected to remain for the wind-ups. I remind members that there is less of expectation that members stay for the next two speeches once they have spoken. This is to help manage attendance in the room. Members may wish to stay beyond their speech, but they should be aware that in doing so they may prevent members in seats in the public gallery from moving into the horseshoe, which obviously is not going to be a case today because we're not oversubscribed. Can I say order, Joanna Cherry to move the motion?
Thank you, Mr Twigg. It's a pleasure to serve under your chairmanship, and I rise to move the motion that this House has considered the Lord Chancellor's oath and the rule of law. I should start by declaring an interest here as a non-practising member of the Scottish Bar, the Faculty of Advocates, as an honorary bencher of the Middle Temple, and also as the lead petitioner in the case of Cherry against the Advocate General, in which connection I refer to my entry in the Register of Interests. Mr Twigg, the Lord Chancellor is required to make an oath that no other member of the Cabinet is required to make, and it reads as follows. I do swear that in the office of Lord High Chancellor of Great Britain, I will respect the rule of law. And when the Lord Chancellor took oath in July last year, he took office in July last year, he took that oath at the Royal Courts of Justice. Yet, Mr Twigg, the past year has not been a happy one for the United Kingdom Government in respect of the rule of law. In September last year, the Government suffered defeat in the Supreme Court of Scotland and the Supreme Court of the United Kingdom when the Prime Minister's prorogation of Parliament was ruled unlawful. And rather than a contrite response, what we saw was a combative one laced with denial. And the fallout of these cases, the Miller case and my own case, and the first Miller case, has been to lead to repeated attacks on the legal profession and the judiciary, and now also proposals to restrict the right of judicial review of government action. So that was the start of the Lord Chancellor's year of office. First year of office. It's been bookended this September by the UK Government's Scottish law officer's resignation, and it will be recalled that the Advocate General resigned last month with a letter informing the Prime Minister that he found it increasingly difficult to reconcile his obligations as a law officer with the Government's policy intentions, and he has yet to be replaced. Now, the Advocate General for Scotland tendered his resignation in the wake of the Secretary of State for Northern Ireland's statement that the UK Internal Market Bill would break international law in a very specific and limited way, an admission that, of course, was elicited from him by the Honourable and Learned Member for Bromley and Chislehurst. In addition to the Internal Market Bill, we currently have two further bills before Parliament which are unprecedented in legal terms. Both the Overseas Operations Bill and the Covert Human Intelligence Sources Bill both seek to create special classes of defendants in domestic law in respect of whom the criminal law will not apply as it does to you or me, Mr Chair. And we also have reviews in administrative law and human rights pending, which would appear to threaten the scope for British citizens to challenge unlawful actions of this government in court. And of course, Part 5 of the Internal Market Bill already seeks to do that in respect of certain aspects of the Northern Ireland Protocol. There are concerns, Mr Chair, that the Internal Market Bill will undermine the Good Friday Agreement, and it certainly runs a coach and horses through the devolution settlement and makes a nonsense of promises made to Scottish voters during the 2014 independence referendum. Now, last week, Mr Chair, I spoke at a webinar organised to discuss the implications of the Internal Market Bill for the rule of law, and it was organised by the International Bar Association's Human Rights Institute. The webinar was attended by over 1,000 lawyers from across these islands, and there were a further 1,000 in the waiting room that were unable to get in. And amongst the speakers who expressed concern about the implications of the Internal Market Bill for the rule of law were not just lefty lawyers like myself, but also the Baron Howard, Michael Howard QC, the former leader of the Conservative and Unionist Party, former leader of Her Majesty's opposition, who I don't think in any stretch of the imagination could be described as a lefty lawyer. So the concerns I'm articulating today are felt across the political spectrum. And it was very noteworthy that during that seminar, Lord Neuberger, the former President of the Supreme Court, expressed very grave concerns about the implications of the Internal Market Bill for the rule of law. And such concerns, when expressed in such trenchant terms as have been widely reported by a former President of the United Kingdom Supreme Court, are of some significance. And they reflect the huge and widespread concern across these islands, expressed by the law societies and the bars of Scotland and England and Wales, about the bill, but also about rhetoric employed by the Home Secretary and the Prime Minister in respect of the legal profession. Now, at the beginning of September, the Home Secretary claimed that, I quote, activist lawyers were frustrating the removal of migrants from this country. Now, days later, an immigration solicitor was the subject of a violent racist attack in a London law firm, and the Law Society of England and Wales wrote to the Home Secretary, warning her that inflammatory rhetoric has consequences. But nevertheless, Mr. Chair, the Home Secretary has doubled down on her rhetoric, and she's been joined in it by the Prime Minister. At the Conservative Party conference, the Home Secretary criticised people who make endless legal claims to remain in respect of asylum cases, and in the same speech she referenced those who lecture us on their grand theories about human rights, as well as do-gooders and lefty lawyers. And the Prime Minister, in his conference speech the next day, reiterated the sentiment, saying that the government were changing the law and stopping the whole criminal justice system from being hamstrung by what the Home Secretary would doubtless, and rightly, says the Prime Minister, call lefty human rights lawyers and other do-gooders. Now, Mr. Chair, the leader of the Scottish Bar, the Dean of the Faculty of Advocates, was so concerned about these comments that he's written really what I would call an unprecedented letter to the Prime Minister, in which he has expressed grave concerns on behalf of the whole Scottish Bar. And I'd like to read it out because it's a short but powerful letter. And it starts as follows. Dear Prime Minister, as I hope you know, the Faculty of Advocates represents the Scottish Bar. All advocates qualified to practice before the Scottish courts are members of faculty, and all are bound by the cab rank rule. And he goes on to explain that the cab rank rule means that advocates must be available for instruction by all and can't pick and choose their clients. And he goes on to say, against that backdrop, I require to intimate as Dean of Faculty and on behalf of all members of faculty that I deprecate the recent pronouncements from the Home Office, then from the Home Secretary, and latterly from the Prime Minister himself, to the effect that there is a problem with lefty lawyers or activist lawyers who are hamstringing the justice system. Whether the topic is immigration or crime or the Constitution, lawyers that act against the state are not being lefty nor activist. They are doing their professional duty. It is simply unconscionable for Her Majesty's government to decry in this way the actions of professionals who, as the comments of Lord President Ingalls in the famous case of Batchelor versus Patterson and Mackersey, these comments make clear that lawyers are not at liberty to pick and choose between their clients. And the Dean of Faculty goes on to say, in this country, by which I presume he means Scotland, but I think he would also apply it to the whole of the United Kingdom, he says, in this country, and the same cannot be said of all countries, instances of violence against lawyers are fortunately rare. However, in a climate of increasing populism, this sort of rhetoric is not only facile and offensive, it is potentially harmful. With great power comes great responsibility. And I have to say, says the Dean of Faculty, with great respect, that I simply cannot fathom why it is thought in any way appropriate to attempt to vilify in public those that are simply doing their job in accordance with the rule of law. I would accordingly, and again with great respect, ask each of you to eschew such unhelpful language and to recognise that challenges to the executive are a necessary part of our democracy. Anything less would be a confession that we no longer live in a democracy. And that letter is signed by Roddy Dunlop QC, Dean of the Faculty of Advocates, who I think, as an old friend of mine, I can assure you, he's not, unlike me, a lefty lawyer. He's simply somebody who cares about the rule of law. Now, I realise as I look around this debate that there are many lawyers in the debate, Chair, and I don't think I need to take up too much time by defining what the rule of law is. That great English jurist, Lord Bingham, has set it out very finely in his 8 principles of the rule of law. But it's worth just reminding ourselves, in relation to the Internal Market Bill, that the 8th principle, the 8th of Lord Bingham's principles, is that the state must comply with its obligations in international law as in national law. Now, turning to the responsibilities of the Lord Chancellor for the rule of law, I think these were very well set out in a December 2014 report from the House of Lords Constitution Committee, where they said, and again I quote, "The rule of law is a fundamental tenet of the United Kingdom Constitution. In the context of the government, it means more than a simple compliance with the letter of the law. It means governing in accordance with constitutional principles. The Lord Chancellor has traditionally had a key role to play, both by defending the independence of the judiciary and by ensuring that the rule of law is respected within government. The Constitutional Reform Act of 2005 substantially changed the office of Lord Chancellor. He's no longer the head of the judiciary or Speaker of the House of Lords, and since 2007 the office has been combined with that of the Secretary of State for Justice. Yet the duty of the Lord Chancellor in relation to the rule of law remains unchanged. This duty extends beyond the work of the Ministry of Justice and requires the Lord Chancellor to ensure that the rule of law is upheld within the Cabinet and across government." End of quote. They also emphasise, Mr Chair, that the Lord Chancellor has traditionally performed an important oversight role in relation to the United Kingdom Constitution as a whole, and I would argue that this is highly relevant to the implications for Northern Ireland and for Scotland's place in the Union, which arise from the Internal Market Bill. And indeed, the House of Lords Committee heard evidence from Lord Faulkner, who of course was very much involved in some of these reforms which took place under the previous Labour government. The House of Lords Committee heard evidence from Lord Faulkner that the Lord Chancellor has a special role to protect the rule of law, and that to think otherwise was to undermine what the Constitutional Reform Act actually had sought to do. So, in summary, the Lord Chancellor's duty to respect the rule of law extends beyond the policy remit of his or her department, and it requires him or her to seek to ensure that the rule of law is upheld within the Cabinet and across the government. And my purpose in bringing this debate today is to draw attention to the very real threats to the rule of law currently posed by actions of this government, and to ask the Lord Chancellor, having regard to his oath, what he intends to do about them. Now, there have been trenchant criticisms from a number of quarters, very fully rehearsed in debates in this House, about the legal implications of Part 5 of the Internal Market Bill. For example, the Bar Council and the Law Society of England and Wales have said that the clauses contained in Part 5 of the bill, and I quote, "enable ministers to derogate from the obligations of the United Kingdom under international law in broad and comprehensive terms and prohibit public bodies from compliance with such obligations. They represent a direct challenge to the rule of law, which include the country's obligations under public international law." And as we have heard, that is why the Advocate General for Scotland tendered his resignation. Now, the Attorney-General for England and Wales has attempted to justify her support for the Internal Market Bill by reference to the legal doctrine of the supremacy of Parliament and the judgment of the UK Supreme Court in the first case taken by Gina Miller about the circumstances surrounding the triggering of Article 50. Now, in that case, the Supreme Court held that to be binding in domestic law, treaty obligations require to be enshrined in an Act of Parliament. But they also held that treaties between sovereign states, such as the Withdrawal Agreement, have effect in international law and are not governed by the domestic law of any state. And they were quite clear that such treaties are binding on the UK under international law. Now, I believe that the Attorney-General has selectively quoted this case in order to justify her view of the Internal Market Bill, and I want to know if the Lord Chancellor agrees with me that a proper reading of the case makes a very clear distinction between the domestic law and the doctrine of supremacy of Parliament and the United Kingdom's international legal obligations. And this was made very clear when Professor Catherine Barnard, Professor of European Law at the University of Cambridge, gave evidence recently to the Committee on the Future Relationship with the European Union. She was crystal clear that while the United Kingdom Parliament may be sovereign under domestic law, this does not impact on the rules of international law. And Articles 26 and 27 of the Vienna Convention mean that in international law, international legal obligations take precedence. Professor Barnard also explained that there is a strong argument that the very existence of the bill itself, it puts the United Kingdom in breach of its duty of good faith under Article 5 of the Withdrawal Agreement. Now, I emphasise this because I've no doubt it will be argued later today that the government amendments prompted by the action of the Honourable Member for Bromley and Chislehurst cure any problems that the Internal Market Bill Part 5 poses for our international legal obligations. I'm going to argue that's wrong for a number of reasons, and one of the reasons is the argument outlined by Professor Barnard that the very existence of the bill, the existence of the evincing of an intention to unilaterally breach an agreement freely entered into less than a year ago, in itself is a breach of the Withdrawal Agreement and our duty of good faith under that Withdrawal Agreement. Now, I know that many cheerleaders for the bill in Parliament have been keen to emphasise Section 38 of the Withdrawal Act, which restated the principle of the sovereignty of the Westminster Parliament. Of course, Mr. Chair, that doctrine is a doctrine of the domestic law of England. It doesn't reflect the Scottish constitutional tradition, but that's perhaps an argument for another day, but worth mentioning because this Parliament here is a union parliament, a parliament that was created by a treaty between two sovereign nations, Scotland and England. The United Kingdom is not a unitary state. It's a state of two countries that came together to form a union. And this is a fact which is of relevance when we come to look at the impact of what is now Clause 47 of the Internal Market Bill on the supervisory jurisdiction of the Court of Session in Scotland. It's also a point which may be of some relevance should the Scottish Government carry out its threat to litigate over the terms of the Internal Market Bill. Now, the Honourable Member for Stone, who I have in common with him a great respect for Lord Bingham, but otherwise in relation to many matters of law we rather depart ways. But he has been peddling a line in Parliament that there's a history, albeit a limited one, of acts of Parliament which have broken international law. But I was very pleased to hear Lord Sumption say very trenchantly recently in an interview on The World at One that this argument that the Honourable Member for Stone has been advancing is, and I quote, absurd. And Lord Sumption said it's absurd because it ignores the fact that sovereign states, such as the United Kingdom, can limit their freedom of action by treaty, and very frequently do, just as the Prime Minister did last year when he signed the Withdrawal Agreement. And Lord Sumption stressed that there's no right to pull out of a treaty unless the treaty itself enables a party so to do. And a party to a treaty cannot disregard parts of it at will. That is a matter of international law. There's also a potential problem, and I'd like the Lord Chancellor and his representative here today to address the problem with the Ministerial Code. And again, I'm not going to say what I think about the Ministerial Code. I'm going to say what the former Deputy Prime Minister, Sir David Lidington, said in a letter to the Times last month, when he said, "Sir, my old friend Sir Bernard Jenkin is mistaken in believing that revisions to the Ministerial Code in 2015 removed the duty to comply with the UK's international legal obligations. My clear understanding, as a serving minister at that time, was that international law continued to be covered by the general duty placed on ministers to uphold the law. In 2018, a campaign group sued the May government, alleging that the 2015 change meant that we had abandoned our international legal responsibilities. The Court of Appeal found their case to be unsustainable and ruled that a minister's overarching duty to comply with the law included international law and treaty obligations, even though these were no longer explicitly stated in the Code." And that's the end of Sir David Lidington's letter. Now, the Lord Chancellor's minister will know that Sir David was referring to the Gulf case. What I want to know is, does the Lord Chancellor's department accept that Sir David Lidington was correctly stating the law? And if so, what does the Lord Chancellor make of his duties under the Ministerial Code in relation to a bill of this Parliament, which, according to Professor Catherine Barnard, the very existence of which is a breach of international law? The Lord Chancellor himself has endeavoured in the public domain to justify the fact that he hasn't, unlike the Advocate General for Scotland, resigned as a result of this bill. And he told Sky News last month that he would resign if the government broke international law in a way that cannot be fudged. I wonder whether we could have it explained to us today whether the Lord Chancellor's position is that the UK government is already breaking international law, but he's happy with that because they're doing it in a way that can be fudged. He also said that he will resign only if the government break the law in a way that is unacceptable. And I'd like to hear today, what is an acceptable way of breaking the law? I'm sure the thousands of ordinary members of the public who've been fined for breaking lockdown regulations, while Mr Cummings did so with impunity, would like to know from the Lord Chancellor's department how he distinguishes between acceptable and unacceptable breaches of the law. Now, the Lord Chancellor has also tried to argue that the amendments crafted by the government and prompted by the Honourable Member for Bromley and Chislehurst mean that the powers now contained in Part 5 of the bill will only be used if the European Union is in material breach of its obligations. And he's described it as a break glass in case of emergency provision. Now, there's a number of problems, I would argue, with this argument. First of all, there's the evidence of Professor Catherine Barnard, who told us that the future relationship with the EU committee, that the very existence of the bill itself, there's a strong argument that that is already a breaking of the obligation of good faith in the withdrawal agreement. Some of the other arguments have been very well made by a speech by our former Prime Minister, the Right Honourable Member for Maidenhead in the Commons just a few days ago. And she said, and I quote, "I recognise that my honourable friend, the member for Bromley and Chislehurst, has taken every effort to ameliorate the impact of these clauses." She was referring to Part 5. She went on to say, "and the government have accepted and put down their amendment. But frankly, my view is that to the outside world, it makes no difference whether a decision to break international law is taken by a minister or by this Parliament. It's still a decision to break international law." And that's the end of the quote from her speech. And I would point out that we have seen very much from comments not just of the Irish Foreign Minister, who described these amendments as smoke and mirrors, but also from comments from both senior Democrat and Republican politicians in the United States of America, that what really matters is the international perception of this bill. And I think what the former Prime Minister was trying to persuade her colleagues in government is that these amendments really don't make any difference to that international perception of what this bill is doing and seeks to do. Now, the former Prime Minister also reminded us that in the withdrawal agreement, there's an arbitration process set down. And she said, and I quote, "There is an arbitration process available. Under Article 175, the ruling of the arbitration panel should be binding on the UK and the EU. The government have acknowledged the existence of the arbitration procedure, but they're saying that they would enter into that in parallel with the operation of elements of this bill. The message, it seems to me, is very clear, which is, if we don't like the outcome of the arbitration panel, then we will break international law and we will not accept it." Yet again, that is breaking the international treaty, an agreement that the UK government signed, because it's breaking Article 175, which says that the view of the arbitration panel shall be binding on both parties. End of quote. Those are the words of the former Prime Minister of the United Kingdom, the Right Honourable Member for Maidenhead, not mine. And I wonder whether, in the light of this very distinguished criticism, if I may so, how the Lord Chancellor can reconcile his support for this bill with his oath of office. Now, finally, Mr Chair, I want to turn to look at the implications of the Internal Market Bill for the union between Scotland and England, and also for the position of Northern Ireland, which I'll address first. And in addressing the implications of this bill for Northern Ireland, I make no apologies again for quoting what the former Prime Minister said in her speech about this bill in the Chamber. She said, and I quote, "I believe that the government's willingness unilaterally to abandon an international agreement or parts of an international agreement they have signed, and their willingness to renege on an agreement they have signed, will lead, as has already been made clear in an intervention, to some questioning the willingness of the government to fully uphold the measures in the Belfast Good Friday Agreement. That, in turn, will lead to some communities having less willingness to trust the United Kingdom government, and that could have a consequence on the willingness of people in Northern Ireland to remain part of the United Kingdom. So far from acting to reinforce the integrity of the United Kingdom in pursuit of trying to appear to be tough to the European Union, I think the government are putting the integrity of the United Kingdom at risk." Close quotes. Again, the words of a former British Conservative and Unionist Prime Minister describing the implications of this bill for the Good Friday Agreement. Also, Mr Chair, it has very concerning implications for undertakings made in respect of human rights protections in the north of Ireland from the British government, both in the Good Friday Agreement and in the Withdrawal Agreement. Again, not my view, or not just my view, the view of the Northern Ireland Human Rights Commission and the Equality Commission for Northern Ireland, who have advised, and I quote, that the bill undermines the Belfast Good Friday Agreement to ensure incorporation of the ECHR, including access to the courts and remedies for the breach of ECHR rights. The Commissions are further concerned that the proposed amendments risk diminishing the commitment in Article 2.1 of the Northern Ireland Protocol to ensure there is no diminution of rights, safeguards or equality of opportunity as the United Kingdom leaves the EU. Close quotes. And I think it's been made very clear in the Chamber by honourable members who represent the Social Democratic and Labour Party and the Alliance Party in the north of Ireland that these concerns about human rights implications of the Internal Market Bill go right to the heart of the Good Friday Agreement. And indeed, litigation is already contemplated by a group of concerned Northern Ireland citizens who have instructed solicitors and counsel. Now, turning to the position of Scotland, which, of course, as the Member of Parliament for Edinburgh South West and the SNP's Justice and Home Affairs spokesperson are of particular concern to me. As well as breaking international law, the powers which the UK government seeks to give itself in the Internal Market Bill constitute an unprecedented threat to the powers of Scotland's Parliament and the devolution settlement. Now, why is this relevant to the Lord Chancellor's oath to uphold the rule of law? It's relevant because, as we saw from the House of Lords Constitution Committee report, the Lord Chancellor also has an important role in protecting the Constitution of the United Kingdom. And the Constitution of the United Kingdom includes the devolved settlement. Now, last weekend in Scotland, we marked the 20th anniversary of the late and very distinguished Labour Party politician, Donald Dewar, who was Scotland's first ever First Minister under devolution and the architect of the scheme of devolution set out in the Scotland Act of 1998, whereby every power not specifically reserved to this Parliament is devolved to the Scottish Parliament. But what this bill does, Mr. Chair, and this is not my analysis, I am reading now from the analysis of Professor Michael Keating of the Centre for Constitutional Change. What this bill does is, for the first time, to introduce a new principle into the devolution settlement by providing broad cross-cutting powers to allow ministers to enforce internal market provisions across devolved fields. And Clause 50 reserves state aid to Westminster after a dispute in which the Welsh and Scottish governments argued that it had been devolved. And Clause 48 gives UK ministers wide powers to spend in devolved fields, which changes the previous assumption that they would spend only in reserved fields and that, with a few exceptions, financial transfers to the devolved administrations would go through the block allocation governed by the Barnett formula. Now, that is why that succinct analysis by Professor Michael Keating is the explanation of why the bill undermines the devolved settlement. Holyrood is not getting any new powers that it didn't have already, but Westminster is getting sole control over state aid back, and in order to enforce the internal market, UK ministers are getting an explicit power to cut across decision-making by the Scottish Parliament in a whole range of devolved fields. And it seems to me that what we are seeing, Mr. Chair, by virtue of those provisions of the bill, is a rebalancing of the constitutional settlement insofar as devolution is concerned, and a tearing up of the very clear delineation between reserved powers and devolved powers that was devised by the late Donald Dewar and set out in the Scotland Act of 1998. Now, this is very important, not just because it undermines the devolved settlement, but it's important from a wider constitutional perspective. Because in 2014, when people living in Scotland were asked whether they wanted to remain part of the United Kingdom or to become or to return to our previous status as an independent sovereign nation, various promises were made by those urging us to remain part of the United Kingdom. In particular, that if we did so, our Parliament would get more powers, would be strengthened, and would become, to quote another Labour politician, the most powerful devolved Parliament in the world. But these weren't promises just made by Labour politicians. They were promises made by Conservative and Unionist politicians, who of course now are the party of government in the United Kingdom. And in 2016, a further Scotland Act was passed, which put the Sewell Convention on a statutory basis and entrenched the Scottish Parliament against abolition. In terms of Section 63A of the Scotland Act, it cannot be abolished without a referendum in Scotland. The Internal Market Bill circumvents these protections, not by abolishing the Scottish Parliament, but by removing the power it previously had to act unilaterally across a whole range of competences which impact on the day-to-day lives of people living in Scotland. It's a very significant change, and some would say a complete and absolute undermining of the devolved settlement, which 75% of people voted for in the 1997 referendum. And we now know, thanks to the decision in the United Kingdom Supreme Court in the first Miller case, that the Sewell Convention wasn't justiciable despite being put on a statutory footing. And we also know, because of subsequent actions of this government, that the Sewell Convention cannot protect the devolved settlement. The Sewell Convention, of course, says that Westminster will not normally legislate with regard to devolved matters without the consent of the Scottish Parliament. But recently, Mr. Chair, that has been honoured more in the breach than in the observance. Last week, the Scottish Parliament withheld legislative consent to the Internal Market Bill, but nobody seriously thinks that it won't proceed because of that. Indeed, the Institute for Government have recently said that the Sewell Convention has been broken by Brexit. I would argue that this bill, the Internal Market Bill, breaks the devolution settlement. And that's important because, as I've said, the constitutional relationship, the Constitution of the United Kingdom is the responsibility of the Lord Chancellor. And the constitutional relationship between Scotland and England is not just about devolution, it's also about the Act of Union. And that Act of Union continued because of promises made in 2014, which are broken by this bill. And I would suggest, Mr. Chair, it has been the suspicion of many people in Scotland for a long time that the British government's word is no longer its bond. That is a perception reinforced by this bill. But the problem for the Lord Chancellor is it's not reinforced just in Scotland. It's reinforced across the world. In Europe and as far as the United States of America, there are concerns about the implications of this bill for the rule of law. Just one final word on the Scottish aspects of this bill, because I've written to the Lord Chancellor about this and not as yet received a reply. I know he is a busy man, but I would be keen to know his position. Because I, like many lawyers in Scotland, not all of whom, like myself, want to see an independent Scotland, but all of whom care about the independence of the Scottish legal system, we're very concerned about the provisions in Part 5 of the bill and their implications for the supervisory jurisdiction of the Court of Session, the implications for judicial review. Because in Scotland, judicial review is part of our system of civil justice, which is a devolved matter under the Scotland Act and therefore the preserve of the Scottish Parliament. But more importantly, in the constitutional context, the pre-devolution context, the authority and privileges of the Court of Session, including its inherent supervisory jurisdiction, are protected by Article 19 of the Treaty of Union between Scotland and England. And it states, and I quote, that the Court of Session or College of Justice do after the Union and notwithstanding thereof remain in all time coming within Scotland as it is now constituted by the laws of that kingdom, and with the same authority and privileges as before the Union, subject nevertheless to such regulations for the better administration of justice as shall be made by the Parliament of Great Britain. Now, Mr. Chair, it is a view widely held that legislation which sought to narrow the scope of the Scottish Court's powers of judicial review and to curtail the right of judicial review could scarcely be described as for the better administration of justice. Accordingly, should this United Kingdom government seek to circumscribe the supervisory jurisdiction of the Court of Session, then they would be interfering not only with the devolved powers of the Scottish Parliament, but also with the Treaty of Union. Now, I would respectfully remind the Lord Chancellor, as I did in my letter to him, that there is a large and respectable body of legal opinion to the effect that some parts of the Treaty of Union between Scotland and England, including Article 19, are so fundamental that the United Kingdom Parliament doesn't have the power to legislate in contravention of them. Now, this is an argument that has been discussed in a number of cases, but never definitively ruled upon. If it's intended to restrict the right to judicial review in Scotland, then I would venture to suggest that this might be the opportunity to get a court to definitively answer the question about the entrenchment of fundamental parts of the Treaty of Union. And of course, the outcome of such a litigation could have potential knock-on effects for the Union itself. So to summarise, really, my argument about the Internal Market Bill in relation to Scotland is we need to see it not only through just the prism of devolution, a modern development, but also through the prism of the Treaty of Union between Scotland and England. Without a Scottish law officer in place, this is an area in which the Lord Chancellor would be well advised I respectfully submit, to take more of an interest. Now, I don't want to take up any more time because I know other honourable members want to speak. I just finish by saying that I've argued that there's a pattern here, and it's a pattern that the United Kingdom is finding ways to worm its way around laws and agreements freely entered into. And because of his oath to respect the rule of law, the Lord Chancellor is in a different class of minister. And the question is, what is he going to do about this pattern? What is he going to do to honour his oath? I note that in his speech on taking office, he spoke of his illustrious predecessors as Lord Chancellor of England and drew a comic veil over some of the less illustrious ones. And I guess, Mr. Chair, my question for the Lord Chancellor today is, does he want to be remembered as a Thomas More or a Richard Rich?
The question is that this House has considered the Lord Chancellor's oath and rule of law. Can I just say one thing first? The call list will be Sir Robert Neal, Rob Butler and Anthony Brown in that order. I would like to call the opposition spokesperson, the Minister, around 10:40 and give the member in charge a minute or two to respond at the end. So, Sir Robert Neal.
Thank you very much. We get some